Thank you all so much for being here. My name is Yolanda Fair, and I'm the project attorney here at the Office of the Juvenile Defender. Today, we are having our monthly virtual series, and I'm excited to have with us Veronika Monteleone, who's an assistant public defender in the Mecklenburg Public Defender's Office. Veronika is an avid champion and advocate of juvenile justice and youth rights. She graduated from the UNC School of Law in 2015. And then began her career at the Council for Children's Rights, representing youth in civil commitment proceedings and juvenile delinquency court. She became a board-certified specialist in juvenile delinquency law in 2021. And is a certified juvenile training immersion program trainer. She, again, is currently a public defender at the Mecklenburg Public Defender's Office, but prior to that, she was an assistant public defender at the Gaston County Public Defender's Office, where she was also the juvenile court supervisor. And so it is my pleasure to turn it over to her to talk to us about the importance of collateral consequences of juvenile adjudications.
Welcome, everyone. Thank you for joining us for this session. I think it's a really important thing for us to discuss. A lot of the times you will hear things like juvenile court doesn't matter, adjudications are not convictions, everything is sealed. So what's the impact of having a child come through juvenile court and being found responsible for a crime? And that's what I'm going to be addressing with you all, and hopefully you'll see that it's a little bit more complicated than that, and it can impact not only our young clients, but also their families in certain contexts as well. So kind of the first things that we want to address and talk about are, is juvenile court really this sort of secret, safe space where nothing is revealed about what's happening with your children that you're representing, right? So we'll go into it a little bit more, but this is just kind of a roadmap of some of the things that hopefully will be addressed in this presentation. First of which, again, is addressing whether or not juvenile court really is a sort of secure place where nothing can leak out. We're obviously going to talk about specific collateral consequences in different areas. We're talking about consequences in juvenile court, potentially criminal court. If our children end up in criminal court, we're talking about immigration and housing and some of those other things that are impacted. So we're going to be addressing both kind of the immediate collateral consequences for our clients, as well as some of the more longer term consequences that are going to follow them into adulthood. And then also wanted to spend a little bit of time talking about, what can we do instead of adjudication? Because we know that there are consequences to the adjudication. Is there anything that we can do to prevent this from even becoming an issue in the first place? So is juvenile court really this big secret that we are maybe led to believe initially, right? Juvenile records are supposed to be sealed. We're talking about confidentiality here. So actually the first thing that I really want to talk about is point number 4 here, is that court hearings are open until closed. And if you've been practicing in juvenile court, you probably know this, right? When your client comes into court, there's often other court counselors there. There are social workers there. There may be individuals from schools who are present. There may be other families who are present. So it can often be a packed courtroom, even though you obviously know that not everyone in that courtroom is going to be there for your specific client's case. I do want to highlight the fact that you can make a motion to close the courtroom. This is something that's available in any case. It's in the discretion of the judge. I will often do this, or have often done this, in particularly sensitive cases where there might be allegations of a sexual nature, or if I know that my client is going to be very sensitive to having other people present who may be very shy, or just maybe more comfortable knowing exactly who's going to be in the courtroom we discuss. There's going to be a prosecutor, judge, obviously me as your attorney, your parents. Beyond that, they may not be comfortable with that, so you can always make a motion to close the courtroom. So there is, a limit on the access to juvenile records. The statutory citations are right there if you want to know in a little bit more depth. We're talking about 7B 3000, 3001. So, you know, there is a certain amount of sharing of these records between certain parties and under certain circumstances. Oftentimes you'll need a court order in order to share those records beyond what's listed out in the statute. And then you can always seal records, which is means that they're going to have to go through a different process. And in order for those records to be unsealed, you're going to need an order from the court. There's no exception to that. So let's go into a little bit about sort of the direct categories of collateral consequences. So the first thing that obviously comes to mind is, you know, we're talking about what does this mean for our clients should they come back into the court system, whether that's in juvenile court or criminal court after they turn 18, or if they've already been involved in criminal court. Educational consequences, and then even beyond that, what we're calling real world consequences. We're talking about things that will potentially follow our clients for the rest of their lives. So direct criminal court consequences. So this is something that I've been coming across in my practice at the Public Defender's Office. I've had people reach out to me about this. You know, the common understanding is that that juvenile court, whatever happens there is not going to impact our clients if they go into the criminal adult system. And also, you know, we also want to just briefly address the idea that what happens in juvenile court, if your client ends up back in juvenile court, it's a cumulative system, just like it is in criminal court, right? If you have a client who's been adjudicated of something in the past, that's going to impact their potential consequences in the future if they're adjudicated of something again, right? We're talking about creating delinquency history points and potentially making them eligible for more severe consequences in juvenile court. Prosecutors are now allowed to share information in a juvenile's record with law enforcement magistrates in the courts. And upon request, court counselors shall share juvenile records to officers at the time of an open investigation. And we'll talk a little bit more about that. And then I have not seen this, and I'm curious to see or to find out if any of you have seen this. There is a juvenile sex offender registry that's been created by statute. It is very limited in what offenses actually qualify for a child to be placed on the juvenile sex offender registry. I have never seen it ordered or really even contemplated, but I'm curious to see if this has been an issue for any of you. So feel free, if this is something that's come up in any of your cases, please share. I am curious about it just because it's not something that I've seen that's really been pursued. So as far as direct criminal court consequences, so again, in my practice, I'm primarily, or at this point, exclusively in the adult world. So the things that I'm thinking about in terms of a client's juvenile record are covered under 7B 3000. So if my client was under 21 at the time of a crime that is considered an A1 or higher since the age of 13, the state can use this in their plea negotiation. Now, in practicality, I don't know how thorough the prosecutors are in your jurisdictions, whether or not they're communicating with whoever they have in juvenile court and kind of sharing that information. I have not seen this come up a ton. We'll go on to the next slide that kind of covers where I have actually seen this. But I have not seen them really discuss juvenile records in plea negotiation. I do think that maybe if they're aware of it with a really serious crime that's coming up in adult court, and they're aware of like an extensive juvenile record involving some sort of violent offense, they might bring that up in terms of pretrial release. But again, this is not something that I personally have seen come up as often as some of the other things that we'll be discussing. Under the statute, also an adult probation officer can review record of juvenile adjudications under certain circumstances, and when they're evaluating risk related to supervision. I have not, in speaking with probation officers, I'm not entirely sure whether they are aware that they have this power to do so. Again, I'm very curious to hear from anyone listening if this has been a situation that they have seen come up where the probation office is actually looking into juvenile records. It has not come up in anything that I've seen, but please be aware that probation may review these juvenile records and may ask for additional restrictions on your client's liberty based on those prior adjudications. So this is where I've really seen this come up in the adult world, and that is if my client has an adjudication of a violent offense, that's an A through E felony, that can be used as an aggravating factor in felony cases in adult court. This is one area where I'm pretty confident that prosecutors are trained on this. They are aware of this. And so they will be seeking that A through E adjudication, knowing that they can then use it in an adult criminal case. So please be aware of that. We're also talking about character evidence under 404B. This one, I think, may not be as obvious. Prosecutors may not necessarily have as much information about that, but please do be aware that this could be an issue in an adult case. As well, as far as federal cases, juvenile adjudications can be used in prior record and sentencing determinations by a federal court. I have never practiced in federal court. If this were ever an issue for a client, or if a client had a question about this, I would highly recommend seeking out the advice of someone who works in the federal public defender's office. I have contacts if anyone is in this situation and they're not sure who to ask the question to. Please feel free to reach out to me and I will put you in contact with someone at the federal defender's office who can answer those questions and work with you to make sure that your client is aware of what impact that will have on their case. So moving on next to educational consequences, I do think this is something that was really hammered home to me as a young attorney who was doing juvenile work, was making sure that I told my clients as well as their families that their school is going to know what's going on in juvenile court, whether formally or informally. Now, statutorily, a court counselor is required to make a verbal and written notification to a school if a petition is filed that alleges a felony. I mean, that's just going to happen. I've never seen that not happen. So this is probably one of the more frustrating parts of the practice where your client's not even adjudicated yet. We're talking about an allegation, we're talking about a petition. With some of the more complex cases, it can take quite some time to resolve a case. The school knows about that the whole time, and the school can initiate whatever proceedings it wants as far as school reassignment, regardless of whether or not that child is ultimately adjudicated of anything. So I've had clients who've been reassigned to alternative schools or put into virtual programs because they've not been allowed to attend school for an entire school year, and then only to have their case resolved in a way either through a misdemeanor plea, or maybe the felony ultimately gets dismissed and they've spent that entire year outside of the regular education system. So please be aware that school reassignments, their own sort of disciplinary actions that they have in place for clients, all of that stuff happens without there even being an adjudication in place. All right. So we have to make sure that we're telling our clients, look, I know you haven't been found responsible for anything. This is just the start of the process, but the school is going to be probably speedier than we are when it comes to deciding whether or not you're, responsible for this or what actions they feel that they need to take. And all of that can be going on before we've resolved anything in court. The final note on this slide, I think just very briefly understand that school resource officers are made aware of petitions that are filed. Obviously, if this is a petition based on school conduct, they're going to be aware of that. But regardless, they're going to know. And what that means is that they're going to be treating your child differently than they would another child. They may be keeping a closer eye on them. They may be more likely to suspect wrongdoing. It may impact how they search the children at the school, whether or not they're going to single out your client or interrogate them in a certain situation. So please be aware that this may become an issue with your clients, and advise them of how to handle interacting with school resource officers at school and what rights they have. So continuing on with these educational consequences, there is a new law. I actually just read through the bill that was passed, creating these school threat assessment teams. So everyone knows that we have, culturally and in the news, we've had a lot going on about violence in schools, right? I think we can all agree that this is an issue. And I think the legislature is attempting to address this problem in creating these school threat assessment teams. These are teams that are supposed to be sort of interdisciplinary. They include mental health professionals. I think in theory, the intent here is to facilitate communications with the adults who are working in the school setting so that they can potentially identify issues before we're talking about someone actually committing a violent act, harming themselves or others. However, in my reading of the bill, my primary concern here for our clients is the fact that these school threat assessment teams include law enforcement, okay? So even though, for example, the bill says that information that's shared amongst these team members is supposed to remain confidential, we're talking about law enforcement having access to this information, and we're talking about conduct that doesn't even rise to the level of criminal conduct. We're talking about whatever they deem to be threatening behavior. There is a kind of loosey-goosey definition in the bill about what is threatening behavior. But again, as we just discussed, or as I just mentioned, we're talking about, these are going to be children who are identified. They're going to be singled out based on a somewhat subjective assessment of what is threatening behavior. I think the fact that it can include harm to self and not just others is potentially problematic. And then that information is being shared with law enforcement. Now, what that means for these children is that they're being, watched, they're being monitored, and they're going to be potentially treated differently and perhaps more harshly than other students. So, while the intent here may be good, I think this is something that we really have to watch and make sure that it is not being used for nefarious purposes and that it's not harming our clients. This will be implemented for the next school year. So I think they're still trying to figure out how to put all this in place. And my understanding is also that this bill did not come with any specific funding or any additional funding. So I don't know what all of this is going to mean and how they're going to implement it without having some money in place to make sure that there are adequate mental health professionals who are there to respond, and the appropriate team members are part of these assessment teams. All right, so this is obviously something extremely important for our clients. When you come into juvenile court and you are adjudicated of a felony, that affects your ability to play sports in school. For a lot of our clients who are on the lower end socioeconomically, school may be the only place where they are able to play a sport. They don't have the money to play for club teams. Their parents may not be able to provide transportation for a rec league. Whatever the situation may be, school may be the only outlet that they have for sports, and sports may be their only way out of a difficult situation, right? They rely on the benefits that sports give you. I mean, we all know Sports can teach you leadership, teamwork, all sorts of skills that you can use throughout your life that can be incredibly helpful. And I think to deny these students the opportunity to participate in sports can be a real challenge for them. Luckily, we have had a recent amendment which allows high school students adjudicated of a felony to continue to play sports. That, however, does not apply to our clients who are still in middle school. With middle school, there is an absolute bar for them to participate in any kind of athletic activity through the school. So just please keep that in mind. Help them understand what this could mean for them, and if possible, connect them to other resources so that they can continue to participate in athletics if it's not an option for them at school. So kind of moving on to what we would call the longer term consequences, right? So we've talked about the immediate consequences in juvenile court and potentially in criminal court. Hopefully our clients will not be involved in the criminal system, but should that happen, we've talked about the impact of those adjudications there. We've talked about the impact of the adjudications for our clients who are still in school, right? We're talking about these threat assessment teams. We're talking about SROs having access to information about what's going on in juvenile court, potentially singling them out. We're talking about athletics. Now we're kind of moving on to a different category of consequences, employment consequences. So, you know that juvenile adjudications are not convictions. From what I have seen in employment applications, most of them ask if you've ever been convicted of a crime. Our clients can truthfully answer no. They have never been convicted of a crime. An adjudication is absolutely not a conviction. Now, there are some applications, or there may be some circumstances where there are questions about, have you ever been arrested? Or have you ever been charged? Or have you ever been on probation? And these are slightly more vague, right? You are a juvenile, you're under arrest. You can be charged with something, and you can have completed or be on juvenile probation. I think that's a little bit of a gray area. And you're going to advise your client based on what you think is in their best interest and what they tell you they are hoping to achieve, right? So if honesty would honestly potentially help them out, if they can just say, look, here's what happened. This happened in juvenile court. It's not a conviction, but I do want to just be forthright with you and let you know that, yes, I was arrested on this charge. Sometimes that can be an incredibly powerful thing for our kids to do, and may potentially persuade an employer that this is a truthful, whatever, however you want to frame that, right? Like, this is a kid who's coming here and being honest and taking responsibility. And that may be a bonus for them in the employment context. It's just going to be on a case-by-case basis. And they may ask you for your advice, and you just tell them what you think. There may be situations where I don't want my client to talk about their arrest or probation, because even if they give an explanation, I think it just sounds bad. So unless they're asking something outside of a conviction that may qualify, my general advice to my clients is no, you're not going to talk about anything that happened in juvenile court in the employment context. Student loan consequences. So this can get a little bit nitty gritty. So just very briefly, in general, our clients are eligible for Pell Grants, whether or not they are in custody or out of custody. They are not eligible for federal student loans while they are in custody in an adult or juvenile facility. So that's kind of an unfortunate consequence for them. It's going to be difficult for them to get financing while they are in custody. Work study and some of these other grants, it's not really clear. They may be eligible, they may not. You're just going to have to work with your clients and see what you can find out in their individual specific circumstances. Okay. If you want more information about this, I'm happy to kind of dig into the weeds and figure out what's going on with all of this. But I think as many of us are aware, there's a lot changing with the student loan program and who's kind of making the rules and administering all of this. So I think some of this is going to be on a case by case basis. Housing. All right. Remember at the beginning when I said some of these consequences affect not only our clients, but their families. This is a big one. All right. The housing authority really has a lot of discretion to decide whether or not they want someone living in a residence that they manage. And they can look at any single tenant when deciding whether or not their conduct violates their rules. So you can see here, we've listed out the grounds to evict. They include engaging in criminal activity that threatens the health and safety of others, threatening others' peaceful enjoyment of the premises, and activity involving illegal drugs. Some of that isn't even criminal conduct. I'm not sure what threatening others' peaceful enjoyment of the premises quite means. Does that mean just playing loud music? Does that mean that you have a dog that barks a lot? It's very, very broad, and your client does not have to be adjudicated in order for this to become an issue for them. If you're in a situation where your client is arrested at home and there's a police presence there, and that obviously brings attention to something going on, that could be sufficient. So, anything could really be an issue for our clients here. So we want to make sure that we're talking to them about that. We're asking about that. We're asking about their housing situation and offering to help in any way we can and connecting them to housing resources if eviction looks likely, if they have already been evicted at the time that we are meeting them and their families for the first time. And I think this is also an opportunity to really build a bridge with our clients' families, not just our clients. I can certainly say from my experience that there have been times where I've not gotten along with my clients' families, their caregivers, their guardians, and this may be an opportunity to really kind of build some trust with those individuals and offer some assistance in that regard. Military consequences. So I've had quite a few clients who are very interested in joining the military. And their juvenile adjudications are very relevant. In the military context, our clients are going to be required to disclose all juvenile records, and that could potentially have an impact on their admission. They have to be truthful in this disclosure, or they could be prosecuted. Each branch is different in how it handles this. So you just want to make sure that they're aware that depending on what branch they're applying to, it could make a difference. And they can request a moral waiver. I'm not super familiar with the process for that, but just know that that's an option for them and be willing and able to assist them in that process if that's something that you have the capacity to do.
And Veronica, I might just jump in right there. We did a training last year that was just about military collateral consequences, and it's on the Defender portal, where we had a recruiter come talk about a little bit of that waiver process. So if that is something that is relevant to your practice and to your client, please visit our Defender portal and you'll be able to see a recruiter go through that process a little bit. Okay, sorry, Veronica.
No, that's great. No, thank you. I definitely want to make sure that if we have additional resources on any topic that everyone is aware of that. I've also just kind of spitballing here, thinking about clients who have gone into Tar Heel Challenge. I think they've really assisted them in kind of bridging them into a full-time military career if that's something that they're interested in. So they might also potentially be a good resource to talk to and see how they kind of guide the kids who are in that program into the military. Immigration consequences. I would say this is a very, very sticky area. If you need a specific consult on immigration consequences, again, please don't hesitate to reach out to me. I can connect you to some great people who do this work. This is not my area of expertise. However, we do have to advise our clients that in some circumstances, adjudications can impact immigration, primarily if your client is looking to gain legal status. So less concerning, for example, in the criminal context, my number one concern with my adult clients is usually, does this get you deported? Less of an issue in juvenile court. In juvenile court, we're a little bit more concerned about if you are trying to gain legal status, is this going to bar you from gaining legal status? So if you are trying to become a U.S. citizen, one of the things that they're going to be looking at is whether or not you have good moral character. Does a juvenile adjudication mean you don't have good moral character? Obviously, I would argue it does not. The government may have a different opinion on that. Just be aware that this could be an issue for our child clients. And if you have any specific questions about guiding them through that process, that you consult with an immigration attorney who has obviously a lot more experience in this particular area of the law. But you do have to mention it to your clients that this could become an issue for them, again, if they are trying to gain legal status. So I just want to close talking about kids who commit crimes and what does that mean for their future and for just society in general. What does it mean that kids are committing crimes? Do we have to be afraid, right? Are the kids all right? So this has been done again and again and again. Studies have shown that just because kids are conducting or are engaging in criminal activity as children, it does not mean that they're going to engage in criminal activity as adults. And then also something that I think has not been addressed as much is, are we actually effective in preventing criminal activity with our clients? Are we actually helping them stay out of a situation where they're likely to commit another criminal act through juvenile court intervention, right? I think there is kind of an impulse to think juvenile court is different than adult court. It's supposed to be more therapeutic. We're focused on rehabilitation. It's not the same thing. We're not just talking about punishment, right? We're doing early intervention. We're helping these kids. But in reality, the more that the juvenile court system imposes itself on our clients, the more likely they are to commit a crime in the future. So, I mean, I think this is really an incredible stat that we're getting from this recidivism study. The idea that the more severe intervention, obviously commitment is the most severe intervention, chances of recidivism are the highest. For clients that we have that are diverted, chances of recidivism are the lowest. Now, there could be a lot of different explanations for this, but this is not the only study that has shown that what you really want to do is provide the minimum level of support and then leave them alone. So this is just a great quote, basically highlighting what I said. The lowest levels of recidivism corresponded to the least invasive systemic responses of the juvenile justice system, particularly by intervening with youth short of adjudication. These findings suggest that the most effective investment of sufficient resources is in the community. Again, what we want is for these kids to never even come to court. People who will ask you, who are not familiar with the criminal system, well, if this doesn't work, what are we supposed to do? In the ideal world, we would have funding for mental health resources. We would have housing for everyone who needs it. We would have, we wouldn't have food insecurity. I mean, investing in all of those things is actually what's most effective in preventing criminal conduct. And we see that with children as well.
Veronica, there are a couple of questions that popped up in the chat.
Sure.
Would now be okay? So the first one is, can you please address the consequences of a sex offense if the youth moves to another state that complies with SORNA and requires registration, irregardless of whether it's required to register in North Carolina? And then I'll get to the second one after.
So I will be honest with you, I don't know a ton about that. I know that the only time that's really come up is when, so I practice in Charlotte, practiced in Gaston County. If we have a situation where we think a child is going to be moving into like South Carolina, for example, their registration requirements are different than North Carolina, much more stringent. So I'm happy to look into that specific question, but I don't think I can answer that off the top of my head. If anyone else knows the answer, I would happily share the floor for them. But in terms of clients that I've represented, I've just said, look, here's what it is in North Carolina. I can tell you that if you move somewhere else, it would be different. Specifically, I know that with regard to South Carolina, again, not as lenient as North Carolina is with regard to the juvenile sex offender registry. So I just want to make sure that I tell them this is what it is here. If you're going to be leaving the state, please contact me so that I can make sure that we know what that's going to look like in the state that you're going to be moving to.
Veronica, there's also a question that says, do you have any ideas on how to get prosecutors to understand collateral consequences and to understand the seriousness of these consequences?
Oh boy. So in my experience, and I'm curious to see if other people have had different experiences, the prosecutors that I see in juvenile court are the young ones, right? They're the inexperienced ones. They may be the prosecutors who are attempting to move out of district court, want to move into felonies, and therefore moving into juvenile court gives them an opportunity to be exposed to felony law and sort of get their hands into a new practice area. But they are told, I mean, I know that they are told from within their office that, oh, you're in juvenile court. None of that really matters. It's, you know, whatever happens in there, it's not going to have any dramatic effects for the people that you're seeing in that courtroom. I mean, honestly, just having conversations with them one-on-one. I have also done in my office trainings on some of these juvenile issues and opened it up to anyone who wants to come. So obviously we have some trainings that are exclusively for the defenders, right? We want to share our practice tips. We want to talk about good strategies, and we don't want prosecutors to know about that. But there may be opportunities where there could be a training that you offer, and you do invite the prosecutors to come. You do invite judges to come to learn about these things, because the collateral consequences, there's nothing really defense specific about these things. They should know that. They should know this going into plea negotiations, that this is going to impact our clients. I don't think there's anything gained by hiding the ball here. And maybe making sure that when you're negotiating with them, you say, look, I know you don't think this is a big deal, or, you know, you think that this is only going to stop once my kid is off probation, but let me tell you about my client. My client wants to join the military. This may be my client's only opportunity to get significant job training and potentially helps financially support their family. This is a consideration for my client. Please take that into account when you're offering a plea or speaking with the prosecuting witness in the case and trying to get them on board. So I think you can individually engage with the prosecutors on a case-by-case basis. You can offer some kind of training or cheat sheet and just say, hey, look, I don't know if you're aware, these are some of the consequences that our clients face. And then also just generally treating juvenile court seriously and showing them that this does matter. Maybe by some miracle, on their own, they'll figure out that some of this stuff is going to be impacting our clients, or do their own research. So just being serious about it, doing it on a case-by-case basis, and maybe offering some sort of training to all of the attorneys if that's an option for you. Were there any other questions?
No other questions. I will say that Berja did mention in the chat that Terry did a presentation on some of the sex offender registry issues. Again, I think that was at the end of last year, so it should be on our Defender portal. And we will put some information in the follow-up email about how to access resources on the Defender portal.
Great. I would definitely love to see. I have not seen that presentation. I think that would be helpful for me to kind of understand, especially living on the border of another state, what the impact would be. Other issues, one of the things you may or may not be aware about, there has been, again, recent legislation that has allowed for the release of information about a youth in certain situations, such as when they're on the run. And this is notwithstanding other rules about confidentiality. So I can't remember the specific facts of the case, but this is basically a reactionary response to a single case where a child was on the run, and news really wanted to, there was a big push for the news to release information about this child. So as a result, courts may order the public release of the following information: juvenile's first and last name, a photo, their alleged offense, whether or not there's been a secure custody order issued, a statement based on the juvenile's record and the level of threat that they may pose. Prior to releasing that information, though, the court must make written findings. And so here are the specific written findings: that there's a petition alleging an offense. The juvenile has to be subject to transfer. So that means that the child in this situation has to be 13 years or older. The court also has to find that they present a danger to self or others based on their record or nature of offense, and good cause exists for the disclosure. These are not a super high barrier, in my opinion. I think judges would quite easily make these findings if they're concerned about their electability and the safety to the public, presumably. 13 years or older and charged with any felony. I mean, that could be a 13-year-old who is charged with common law robbery, no weapon used. I mean, this is really not a high standard. And although, and we'll move on to the next slide, this information has to be removed once the child is actually detained. What does that mean? Once you put information out there, how do you take it back? That is an incredibly difficult thing to do. I mean, we can take screenshots. I mean, just thinking about all the ways in which once something is out there, it's going to be there. There's no way to really take it all back. And also, I should have mentioned earlier, there is an exception to this court order if exigent circumstances exist. Again, anyone who's been practicing, exigent circumstances, highly subjective when we're talking about what a law enforcement officer thinks are exigent circumstances versus what we would consider exigent circumstances, a little bit of a different standard. Again, I'm concerned, I think rightfully so, about what this means for our children, releasing their information in such a way. I'm concerned about their safety. I'm concerned about their family safety. And I don't really have a good, happy way to, I don't have any good news about this one. If anyone has any positive spin on this, please let me know. So that is the end of the presentation. But as I've said, in addition to reaching out to me directly, if you have any specific questions or want connection to resources, these are some great resources to look at if you're concerned about potential collateral consequences or actually just juvenile issues in general. I mean, the Galt Center is amazing. But again, if I don't know the answer, I can connect you to someone who does. And that's the great thing about our defense community, particularly our defenders who represent children. We are very collaborative and we will find you the answers that you need. So please don't feel like you are out there without resources, without other people to speak to, whether it's just spitballing about a case or asking a specific question about a potential consequence your child is facing. Please reach out. I think my information is there. That's my email. I'm also happy to share my cell phone if anyone would like that as well. And then, of course, in addition to me, you've got the whole team at the Office of the Juvenile Defender. So these are people who are specifically trained on these issues. They exclusively work in juvenile defense. I don't know how many years of combined experience they have, but they are all wonderful resources for you as well.
So Cole had earlier asked a question, I'm kind of jumping to another thought here, about getting prosecutors to understand these collateral consequences. There's one other resource that comes to mind that I kind of wanted to put on the radar for everybody. The Conference of DAs has, oh, Eric might have to jump in and tell me if it's one or two. I know we have one for sure. I say we, they have one for sure, Kyle Smith. And I think they sometimes have a second. I'm not 100% positive if they have a second right now. But I'm putting Kyle's email address in the chat. He is specifically a juvenile resource prosecutor, which means it's kind of his job to know this stuff specifically. And he is actually very well aware of the collateral consequences. And he makes it a point as much as he can to help other prosecutors understand this stuff as well. He's actually very friendly to work with as well. He was working on putting together a prosecutor manual. There we go. A juvenile prosecutor manual for new prosecutors, because we all know that they often have a lack of resources for this specific stuff, and had asked us to work with him on collateral consequences in particular. So, sometimes you have that DA where no matter what you say, they're going to hear the opposite. And if you feel like you could benefit from maybe having Kyle reach out to him, I don't know if he will every time, but just know that he is also a resource that can help with some of this type of stuff.
It'd be great if he could create some sort of sheet that said like prosecutor at the top of it or something, so that it's coming from their own people. We're not trying to deceive them.
Yes. So that was the project that he was working on. I'm pretty sure he has so much on his plate that hasn't been printed or finalized yet. But is supposed to be the juvenile version of NC Pro, basically, like the prosecutor's manual to juvenile prosecution. And then Eric in the comments also put that School of Government has asked us to present to the juvenile court judges on collateral consequences in the past. So hopefully the judges are hearing us out too. And so hopefully that kind of helps address Cole's question a little bit more too.
I can't believe there's a prosecutor on our side. What?
I didn't say on our side. But no, I've worked with him a couple of times before, and it is refreshing to work with prosecutors. And he's not the only one out there, but I can pinpoint him as one in particular. But it's refreshing when they understand sort of the purpose and the objective and all these extra little pieces that go with it. They're not just like planted in from adult court, let's get a conviction. Actually, let's get 2 convictions for point purposes kind of mindset.
That is refreshing.
I don't think that. Thank you all so much for attending. I apologize. I was trying to make sure I get the link in there. We will send up a follow-up email with a copy of the PowerPoint and some of the resources we mentioned in the presentation. That will also include Veronika's contact information. So please reach out to her if you have any more questions, or reach out to any of us. Thank you so much, Veronika, for being here and for taking your time to teach us about this important topic.
Thank you so much. Thank you so much for having me. And it really is a genuine invitation. If anyone has any questions or just wants any help in any of their cases, I'm happy to help.
Thank you. We will see you all next month for our next training. I hope you all have a great Friday and a great weekend. Thank you for being here.